Hello, I'm Dean Vera. I'm an entertainment lawyer, professor of law, and dean on the College of Law. Today, I will talk about the recent controversy regarding the Bimbo Musical. Is it infringement or is it plagiarism? Stay tuned. Welcome back. Recently, there was a video that won a contest with a prize of 1 million and a management contract. In the winning entry, this person submitted a video where he sang, dramatized, and interpreted several Eraserhead songs, which are similar to the choreography and music of the recent Bimbo Musical that was shown live at the Resorts World Theater. Is it plagiarism or is it infringement? Before we begin, I'll introduce myself. I'm Dean Vera again. I post legal commentary on certain issues. If you're new to this channel, consider subscribing. A like and a share would greatly be appreciated. Now, first, what is plagiarism? Plagiarism is a situation where somebody uses somebody else's work, whether it's a book or a picture, and without citing the source or referencing or giving credit to the author. Usually that is done in the academic field, and the consequences could be as light as a failing grade, well, that's not really light, and to the severe expulsion. What is infringement? Infringement is a legal term wherein somebody's rights were either violated or used without permission. In this case, the property is the intellectual property of the Bimbo Musical. I've seen the video. This person had a unique look with regards to the dramatization of the songs. Yet his songs, the musical arrangement, and the choreography on certain points were very similar to what was done in the Bimbo Musical. I looked at the context mechanics. A person wanting to join the contest has to submit a video with certain limitations, right, such as size, age, and the use of profanity or any abusive language. But it had no restriction on intellectual property. Usually when, for example, in photography contests, the organizer would say that any entry submitted would be owned by the organizers, quite limiting for the contestant. But in this case, there was none. In effect, the contestant would still technically own the video which he submitted to the contest. When the winning entry was chosen, the final cut of the video was shown with the logo or the watermark of the corporate sponsor on the right side. Now, is it plagiarism? I don't want to call it plagiarism because plagiarism is technically, for me, in my opinion, is an academic crime. It's only done in the academic field. Also, and more importantly, plagiarism can be forgiven by correcting or citing the source. In infringement, there is no excuse. Either you did it or you didn't. As an IP lawyer, infringement is always wrong. It's because when an author or a creator makes a work, he puts in his blood, sweat, and tears. He wasted, well, not really wasted, he used up brain cells to create that work. That is why intellectual property is created, to protect and to encourage these creators, these authors, to make more work, knowing that their work is going to be protected years later. In fact, the law provides that a work is protected 50 years after the demise of the author. What has happened? In the recent days, the winning contestant had apologized and in fact credited the Bimbo Musical. That is a smoking gun. What can be done? Well, it's really who owns the work. Is it the Resorts World? Is it the producer? Or is it still the Eraserheads? At this point, I don't know the contractual arrangement between the three parties. But from industry practice is that the author, the choreographer, or the musical arranger had sought license or permission from the original work or the original author, in this case the Eraserheads, and then interpreted or created derivative work, what can be done? If this went to court, a judge who's also human has to seek whether there was substantial copying or substantial use of the work. What's more important is that in the eyes of the ordinary man, whether two works put side to side can be considered similar, very similar, or substantially the same. In my opinion, I believe that there is a cause of action. There is some credibility as to the charge of infringement. What can we learn from this? In today's society, in today's modern world, people post videos left and right. Sometimes it takes effort just to edit these videos. It takes much more work to create the videos. We should award originality and creativity. We should discourage copying or in what you call plagiarism. I hope I cleared some issues here and you have learned a little bit. Remember, it's not what you know, it's what they don't know. Again, thank you for listening and hope you have a great day. Bye.